May it please the court, Judge, I'd like to reserve 5 minutes for rebuttal.
Sure.
Thank you. May it please the court, counsel. We're here on an appeal of a trial court's final judgment. In this case, my name is David Sokol. I represent Biologics. They're the manufacturer of specialty low air loss medical beds. The defendant, PI, and the appellee is a company that makes plastic products and was to manufacture the mattresses for Biologics. The issue before the court was based upon, and on appeal, is based upon the trial court's denial of lost profits. There is no dispute that the product manufactured by PI, the appellee, did not conform, and the only issue here is the non-awarding of lost profits. The issue we've raised on appeal is that the reasons given by the court for its denial, one was that the buyer failed to properly cover. That issue was never raised as an affirmative defense, and the other issues raised on appeal are that no reasonable cover was available and that the seller knew what the buyer was going to be using the mattresses for, and so they could anticipate that the damages that they would suffer if the mattresses were non-conforming, and that there was no speculation or conjecture in the profits that they suffered. Briefly, the facts of the case are Biologics, as a manufacturer of specialty medical beds, low air loss, they do not manufacture their own mattresses. They put together the controllers and they sell the controllers with the mattresses for use in hospitals, nursing homes. It's a patented product, well known in the industry. It's been around for a number of years. They provided the appellee with a sample of the product and a request, can you duplicate that? They had previously been having it made in Taiwan. The appellee said, yes, we can duplicate the product. That contract was signed in November. They put about a 6 to 8 week lead time on that. And finally, the product did not show up until February. In February, the seller manufacturer shipped 40 of the 100 units directly to 4 different locations, which were for a customer known as Universal Hospital Systems.
Now, let me stop you right there. The deal with the hospital supplier was for 40 beds?
Yes, Your Honor.
And the other 60 were just going to go into inventory?
Yes, Your Honor.
Okay, so, and I'm asking this because if we get to the profit question, so that there was a price negotiated already and established by contract with the hospital supplier for the 40?
Yes, Your Honor.
The 60 were going to be in inventory, and that price was not set. There was some testimony about what they had sold for in the past.
That's correct. The principal of Biologics knew that he actually he knew the demand, and so typically when he ordered these mattresses, he ordered them 100 at a time, and he normally did not have any problem going out selling them. There was a very high demand for the product. And there was actually testimony for the other 60 that by one of his competitors who had been in the same industry for over 20 years, that he had never actually purchased one of these mattresses or one of Biologics beds for less than $7,200, and he was surprised at that price. But with regard to the court's determination of could there be speculation or conjecture on that, we would concede that on the 40 beds, there is absolutely no speculation or conjecture. The buyer of those beds testified that he received the 40 mattresses, sent them all back. The day he inspected them, a couple days after they arrived, he realized they were non-conforming, called Biologics. Biologics immediately notified the appellee of the problem and said, we need to fix this. And it was never remedied, and that was in February, and it wasn't until finally April when a determination was made they're not going to fix them. They were then sending their demands saying, pay us the $60,000, $58,000 that you owe us for manufacturing them. We believe they conform. But we would concede with regard to the other 60 that maybe the court would have to make a determination as to what that damage would be. But clearly on the 40, that particular buyer said within a year after that, when the product became available again, by the company that bought Biologics patent. He had purchased over 100 of these beds, and he testified that he had a very high demand for them because his company would go out and rent them to hospitals. So there's no question on that. Back to the issue that we raised with regard to the facts, there is no dispute that the mattresses did not conform.
And there were 3 bases for that?
Pardon?
I recall there were 3.
That's correct, Your Honor. One was the mattresses are used for patients dealing with bed sores, open wounds, and because of that, when they were delivered, they only had an outer cover. They did not have an inner cover, and they had open cell foam. So if any fluids got in there, you could not clean them. You would have to throw them away. So all the previous mattresses they had always had an inner shell, a covering that would be sewn into the inside, and then an outer covering, so the outer covering could be cleaned. There was also a problem where the mattresses are supposed to have microscopic laseroscopic holes, and they did not have those in there. The bed is a low air loss bed. The only way the air can be lost from the bed is through the controller puts the air in, and then the air is slowly leaked out through the laseroscopic holes, and the laseroscopic holes were never put in there. And the third was that the tubing was open and exposed, and we believe the tubing issue could have been solved. Our contention is when it comes to the issue of cover, that no reasonable cover was available because nobody in the country made these mattresses. Nobody testified that anybody in this country, that there was any other place to get these mattresses. The only testimony that came out during trial, and that came from Mr. Hagopian at Biologics and from Nathan, his employee, and from his competitor, was that they buy these from Taiwan, and there was a 12-week delay on that. There was some discussion about the possibility during the first month or so about, well, can we find somebody to put a cover before they realized the problem with the laseroscopic holes? And during that discussion, and there was a letter that was sent saying, well, we can find somebody who can put a cover on them for $175 a piece. That was rejected by them at that point, but later on it was discovered that, well, there were other problems with them, and that being the laseroscopic holes, and it was also discovered that the possible of having this company go out, the sailmaker go out and manufacture a cover was not, FDA requires good manufacturing practices, and nobody testified that this one alternative that an employee found who was not that familiar with it, well, I found a guy that can make some covers and maybe sew them. They hadn't really looked at the product. They had just talked to him about it. That once they got around to examining that, this was not practical. And from our side, and I realize I'm kind of jumping around, but the issues are obviously intertwined.
Why do you think the judge said, let me see what the judge said. The evidence that the problems with the goods could have been remedied by cover is substantial.
I do not believe that that was the testimony, and I'm not going to speculate as to, during the course of the 2-day bench trial, what evidence there was. I think the record stands for itself, and not one evidence that cover was available was in the record. And in Appellee's answer brief, they don't even cite to anything that's substantial. The only citation is, well, the judge said it was substantial, but there was nothing cited as to who testified as to how to fix the problem.
I have a follow-up question. I recognize what the judge said, but then in that same paragraph, the judge said there's some evidence that the demand could have been met by other stock. That's like a whole different standard.
Well, I think what the judge is doing is saying that when the buyer from Universal Hospital Systems testified by videotape deposition, he said on that day when we submitted the purchase orders, each purchase order included 10 of these, for 4 different locations, 10 of these VersaCare mattress systems, and those are the ones that go in the Hill-Rom bed, your common hospital bed that you see as a particular shape is really what it is, and it has to be made to have the flex. All right, 10 of those are purchased. At the same time, the same customer also purchased 2 other different models. One was another dolphin bed that you could use on a standalone, did not sit in a frame, and another one was a bariatric. And the evidence from that was, the judge found, well, because at one point, when they rejected them and sent them back, the Universal Hospital System said, we'll send back the mattresses, but we'll keep some of the controllers, because we can use those, because typically, the mattresses may wear out.
So that gets down to what would have been the calculation of the profit.
That's correct. But that same individual who returned them said, absolutely, we would have paid the $400,000 plus for those beds. We had a high demand for them. And from a practical side, we know they probably could have made their own claim against Biologics for their lost profits.
And your lawsuit, it's not, correct me if I'm wrong, but it was not restricted, was it, just to the loss of profit on that contract?
It was loss of profit on the 100 beds.
Right. So in terms of replacing them with other stock, that still doesn't get you to the lost profits on the ones you purchased.
Well,
I mean, the judge says here you might have been able to replace the defective ones with other stock, but that, I assume out of your own inventory.
And that was just the controllers. I mean, it still means from the fact that the
But if you're suing basically because you were anticipating that you would make a profit on these 100 mattresses,
yes,
replacing them from other stock doesn't make you whole.
That's
or
correct.
Doesn't take care of the issue.
That's correct.
Right.
Yeah. I mean, and that was the customer sort of working with them, saying, all right, we're not going to ship these back.
Wow.
The other ones we can't keep in our warehouse. We have to send those back. But that lost profit, there was no doubt. And from one of the elements is that the manufacturer seller had reason to know. Well, they knew that Biologics was taking this mattress, incorporating it.
So they sent them directly to
and sent directly to the supplier. Well, and to 4 different locations, knowing that they would be spreading them out, at different hospitals in different cities. Was how it works. So from our side, we don't think there was any speculation as to that, and that they could have anticipated that. Back to the issue of the failure to cover was never pled, nor was failure to mitigate, and we think that's the first reason that the judge gives, that he finds that the evidence of cover was substantial. Well, had it been pled, it would have been framed by the pleadings. Additional testimony beyond what came out could have been prepared to say reasonable cover was not available, but it was never pled. And the first time it's brought up ever that this was on their motion for involuntary dismissal at the close of the plaintiff's case, and we objected to it coming out at that time. So we believe that objection was timely, and then the appellee has claimed, well, failure to cover really is not an affirmative defense that needs to be pled, and we've cited several cases to that. The first case we cite, obviously from the Fifth Circuit, dealing with Mississippi Chemical, is interpreting the Uniform Commercial Code for Mississippi, but this Fifth Circuit case goes out and actually makes the analogy that failure to cover is akin to failure to mitigate. And then clearly this second DCA on on several cases have all talked about the failure to plead an affirmative defense, that defense is waived. And one of the cases brought up, on that, as whether it's even if it's failure to plead, you can have the Fisher case dealing with the statute of limitations having not been pled. That's a second DCA case, and they said if you did not plead it, it's been waived. The Myrick case, second DCA 88, that was the non-payment of a note where the borrower had held back some payments because of a lien, and in that case, the only defense that they never raised the failure of consideration defense. They just raised the set-off. In that case, the second DCA said, no, you've waived that failure of consideration defense because you didn't raise it. The Price case, 2008, and that was with the condominium association and the floor that was kind of noisy. And in that particular case, during the trial, they tried to say that, well, the condominium association had ratified approval of this floor, and they said ratification was never pled. So once again, we would assert that the first reason for the judge's denial that there was evidence of failure to cover should not really, that was an abuse, not abuse of discretion, but that was a misapplication of the law on a de novo review, and that was incorrect, simply because that defense was never pled, and a timely objection was made, and that issue was never framed for the pleadings. Even so...
You're at 5 minutes left, so I'm just giving you a heads
Okay.
up. So.
Thanks. Well, then I'll stop, and then I'll save my
Okay.
5 minutes for the rebuttal. Thank you, Your Honors.
May it please the Court, I'm Thomas Sherino, the law firm of Wethington Hamilton, representing the defendant, Applee PI Inc. in this matter.
I didn't quite get your name. I said Thomas?
Sherino,
Spell that last name.
S-C-I-A-R-R-I-N-O.
Okay, I just didn't see on the caption, that's all.
May it please the Court, the trial court in this matter made a reasoned decision and was in the best position to review the evidence as well as the testimony and demeanor of the witnesses.
Was there a pleading deficiency not raised in the affirmative defense that Mr. Sokol just referred to?
No, there was not, Your Honor, for two reasons. First of all, affirmative defense number 8 said that there was a failure to make remedial measures. That is a mitigation or a cover defense, and appellant doesn't really deal with that, doesn't mention that at all. And the appellant was on notice of that affirmative defense and replied to the affirmative defense and just generally denied the affirmative defense in its reply. So it was on notice, remedial measures, cover, mitigation, I think.
Well, one's unique to the UCC, and one seems to be a generic type. Remedial measure is more generic than the UCC.
Yes. And the other is, Your Honor, and I think the court correctly applied the law in this case. This was an action for the sale of goods between merchants of more than $500, and the UCC applies. So
no one seems to dispute that.
right.
Okay.
So statutorily, this was an action for breach of warranty, and statutorily, under 672-715 subsection 2, there's a requirement of cover.
Well, I'm just trying to figure out what the necessity of that sentence about some of the demand for some of the units that may have been met with other stock. Well, how does that relate to anything with the UCC?
Well, because the testimony was, in this case, that the defendant ended up selling beds, similar beds, to the end buyer in this case, that used the same controllers, and the controllers were a big item in this. And that was really the technology that was sold by the plaintiff.
The damage would have been different.
I'm sorry?
The lost profit would have been different as to the controllers versus the mattress themselves.
Well, the controllers were the most expensive part of the bed, and those controllers could have been used with a different mattress, and they in fact were used with a different mattress. And so that was the part about meeting the obligation of the end buyer with some other items out of stock. And that's where those controllers were used, and those controllers are in stock. It wasn't like they purchased those controllers. That was their technology. That was what they manufactured, and that's what they used. And that was the most significant part, and could be used with other mattresses. So, and in fact was used with other mattresses and was sold to Universal Hospital Systems.
So what, though, is the evidence, the substantial evidence of the availability of
The cover? Yes. There were basically three things. One, a letter from the plaintiff, Mr. Hargopian.
Talked about one, correct, about the covers?
Talked about covers that could be replaced for $175 each.
Okay, didn't talk about the micro laser holes.
No, and that really did not even come up, really.
Well, it must have, because it's in the record.
It came up in the record. It came up in the record, but it never came up, as an issue. It wasn't in his letter.
No, but it was in the testimony of trial, was it not?
It was in the testimony of trial that it had this problem, but the defendant was not aware of this problem, of this issue. The issue was the covers. That was the real issue.
You got the testimony that hospital supplier rejected them because of the covers, because of the micro laser holes, and because of the valve tubes, I think, or whatever.
Right. The covering for the air controller, which, as he
Yeah,
was
I'm
pointed
not sure
out.
I fully understood the
Right.
description. In my mind, I had it, was that this was a connection to a valve, but go
Right.
ahead. But it's something like that.
Yes. And also, you know, it's not contained in this letter that this is something else that has to be remedied, or this is something that can be done. There's no evidence that the defendant was aware that this is something else that has to be done. It was all focused on the covers. And covers could have been replaced for $175 each in the letter.
From the sailmaker,
I'm sorry?
or by the sailmaker.
There was
Okay,
no...
what is the effect of that letter being incorrect?
Well, it's because...
It wasn't the evidence that letter was incorrect.
Well, yeah, again, after the fact. Now, we
After
really...
the fact, I mean, you know, it's still non-conforming, and in any event, your client rejected that, did it not?
Rejected the offer.
Yes.
Yes, sir.
What difference does
Yes,
it
sir.
make?
Well, it's because that at the time, there was no, well, we couldn't do this because they weren't compliant or something along those lines. But then later, the other part of the evidence was that my client did come in and offer to replace the covers also. So that was another consideration. And there was also testimony from the competitor that those covers could have been replaced for $20. So there were 3 items that made it substantial that the covers could be replaced.
Okay, now how about the micro laser holes? You're saying we have to disregard that?
I think so, because that...
I mean, how did it even get into evidence?
Well, because it was, you know, it was not something that was pointed out. You know, it was not, we're not on notice as to that as being a problem. So, and there was no, you know, no effort on anyone's part, any of the correspondence, anything that discussed those and talked about those and indicated that was the problem that had to be remedied afterwards. It was all after the fact. And then, and part of the reason why this whole problem about the covers and so forth, there are several reasons why now the defendant, or the plaintiff, did not want to try and remedy the situation, did not want to cover the situation. Number one, he was selling the technology, he was selling the business, and he lost interest in trying to remedy the situation. Number two, Universal Hospital Systems was a large client of his. He took their word that these were not going to, these were not in conformity, took them back, made no effort to try and remedy the situation, no effort to try and do it, just accepted their word. He had done, they were a large...
Well, we know they didn't conform because that's what the judge found.
Correct, but it doesn't mean that he...
Whether they took their word or not, I mean, that's the fact.
The fact that they didn't conform, it doesn't mean that they could not have been repaired or covered, or that cover could have been done reasonably, and it could have been done. But there was no effort taken to do that. He simply did not try to do that. He sold them some other beds. So I believe that, you know, as to those 2 reasons, as to the affirmative defense, I believe it was raised, and as to the cover provision, it's a statutory provision in order to recover that. Then the next question to be decided is whether or not the lost profits are recoverable and whether or not they were in compliance with the requirements of 672-715 subsection 2 that requires that in order to recover these consequential damages, not only do you need cover, but you need proof as to the foreseeability of them, whether or not there was reason to know. There's issues as to whether or not the defendant in the case knew. I know you pointed out...
But the judge didn't go into those, right? The judge just said this is speculative.
He said he didn't point out all of them, but, you know, he considered all the various factors.
We can only go by what the order is, right?
I'm sorry?
We can only go by what the order says. The order
Yes,
focused
sir.
on on the speculative nature of the lost profits.
Speculative and also contradictory. He went beyond being speculative. He pointed out how the...
You know, it seems to me that, and I'm fairly sure this is the case, the law on lost profits about whether they're speculative is the fact of the profit. If the fact of the profit is speculative, you can't get them. But if the fact of the profit is not speculative, then the law requires that you submit a reasonable basis for measuring them. But you don't have to specify what the profit would be.
Well, I
Not
think...
correct?
Well, I think you need to...
In this case, you've got testimony about what this cost to produce, what was to be paid to your client. You've got the testimony about what they were to be sold for to the hospital supplier. You've got
Right.
testimony about what the 60 that were going into inventory, what the range of the sale for those would be.
Right, but what is lacking, and there were several items which were lacking in terms of proof of the lost profits, is that there was a lacking of evidence as to the expenses involved with that.
Well, wait a minute.
I'm sorry? There was no showing, there was no expert testimony
You're
as to
saying
the...
that there's no expert testimony? There would have to be expert testimony?
There was no expert accounting testimony as to the business
Well,
profits and losses.
I think that what you're getting into is cases that talk about businesses that are looking for future profits for like interference with business relationships and such as this. As opposed to here, we have a specific deal. We have a not a startup business. We have one that's been in business a good long time, established place in the market. You know, are you suggesting that that they were going to make a profit off these mattresses was speculative?
The amount of profit was definitely speculative and, in fact, contradictory. In his letter...
Well, the contradictory part doesn't bother me because it's the job of the trial court to find facts often based on contradicting evidence.
Right, but the plaintiff's own evidence should not be contradictory is
Even if it is.
what occurred in this case,
Even
yes.
if it is.
Right. I mean, in his letter...
That should be no impediment to the trial judge finding facts.
Well, but I think when you're talking about lost profit, these are the type of things that have to be considered. What is your basis for the profit? And if on one hand you're saying that my profit in this is $450, and at trial you're saying, no, my profit was $4,775.
Then the judge would probably be well within his right to say, well, I find that the profit was $400.
Right,
That doesn't mean it's speculative as to whether there's going to be a profit.
I agree with you on that, Your Honor. But then there are also items as to the amount of the profit that were not presented in the evidence in terms of what were the costs involved. They were trying to show gross profit, what they were going to sell these for. There wasn't any consideration of what did it cost you? Did you have sales items involved, and so forth. There was also, in terms of who was actually profiting from this deal, because these items were sold by the plaintiff to a third party, a related party, and then ultimately sold to the end buyer, in this case, Universal Hospital.
Now you're arguing like a standing issue.
Well, this type of problem in there, but there was no showing in terms of what was the cost if you're selling it to a third party. What was their profit from that? What was the?
Well, my understanding is there was a contract between the plaintiff or the plaintiff's wholly owned and a specific hospital supplier, and that it was that was the transaction that was at issue in this case. What the supplier was going to do with them was wholly irrelevant, I suppose, to this dispute.
Right, but the end buyer did not buy from the plaintiff in this case. He bought
from their wholly owned subsidiary.
Their wholly owned subsidiary, right. And in terms of what the wholly owned subsidiary was profiting from that, or what they may have obtained, They were not a party to this case. The plaintiff was the party to this case. All the evidence in terms of the profit involved the plaintiff, not the wholly owned subsidiary. And so, you know, that was one of the factors that the court considered in terms of looking at that. And then finally, there was, like I indicated, there was an attempt to show gross profits in this case without, and the case law that's been cited there shows that gross profit is not the proper measure of damages for lost profits, and that was what was done in this case. So, with all of that, Your Honor, we believe the cover or mitigation defense was raised. We believe that the issue as to lost profit was not met by the appellant, and that the action of the ruling of the trial court should be affirmed. Thank you.
Thank you, Mr. Shree.
May it please the court, counsel. With regard to the eighth affirmative defense having been raised and preserved the issue, or at least put us on notice of the issue of failure to mitigate, failure to cover, the eighth defense actually said plaintiff refused to allow any remedial measures and therefore should be denied. A refusal to allow remedial measures is not the same as plaintiff failed to go out and obtain reasonable cover. And to say that's synonymous, you know, what they're getting at is that somehow or another the seller attempted to fix the problem, and because the buyer didn't let them fix the problem, that their buyer's lost profit should be denied. But it's not the same. It just is not failure to mitigate, as we know that defense of being pled, and it is not failure to cover. The issues having to do with the controllers being sold separately and lost profits, there was very specific testimony as to the cost of the controllers. Every item was put in there, and at one point the judge just said, we know what this is. Is there an objection to this? No objection. There were two costs involved, hard costs. One was the mattress, which the appellee knew exactly what they were charging for that, so that cost was not in dispute. The other is the cost of the controller. The bed consisted of two things, controller and mattress. Shipping costs were billed separately to whoever bought them, paid on the back end. Those are the only two costs. So if you subtract the cost of the controller and the mattress from the price being paid, that is the very exact damage amount. And as the court said, and even in the Gottlieb case, which Judge Northcutt concurred in, the intent really is to put the injured party in the same position, and they should not be worse off. The damages should be the benefit of the bargain. In this case, the benefit, in that case, that was the defective sleeves where the fabric was defective that they were using for amputees, and then the buyer there had to basically recall the sleeves that they had sold. And the lost profits should be a reasonable degree of certainty in the mind of the prudent person that the damages are calculable and not speculative. There's no speculation that doing that math, and this even follows along with the Sherry case that cited the reinstatement of contracts. You're allowed to have some inference. And they also talk about if the defendant caused the wrong, they should not be able to complain about the uncertainty. Difficulty in calculating is not fatal. Mathematical precision is not required. The best evidence is the damage, and you can certainly look at the expected profit. And so in this case, the expected profit was certainly the net amount after subtracting your costs for the two items and assuming that the buyer, the third party, paid for them. The issue of that advanced wound wholly owned subsidiary, that is another issue that was never raised at trial. It was raised in closing for the first time. We timely objected, and the judge did note that in his opinion. And further, that issue has not been contested on appeal. So that it's no longer, that stands as being fine, that he used a wholly owned subsidiary. And even the testimony from the buyer was all dealing with Mark. You know, this is the guy he'd been buying them from. It's Biologics bed. You know, he didn't care the name necessarily on the invoice. He knew who he had a relationship when the beds are non-conforming. He immediately called and sent an email to the guy that he'd been dealing with, and that's the president of Biologics. The fact that it was a good customer and they were rejected, I don't think the manufacturer ever really quite realized that the problem with open cell foam. And when you talk to people in the hospital industry, and Biologics has been dealing in the acute care industry for 20 years, open cell foam is in hospitals, in care of wound care, is the worst thing. Between people catching MRSA and other diseases, you cannot have open cell foam. So the moment he was told open cell foam, he immediately agreed and said, "Get this out of there. We agree. You don't have to convince us. This is non-conforming." He did have an incentive, despite the court saying that perhaps he didn't have that much of an incentive, and even opposing counsel saying that he lost his incentive to try to remedy the problem. He had $400,000 worth of incentive. That's the lost profit he would have made on the 100 mattresses been conforming that he would have sold assuming they showed up in January when they should have, that he would have sold between January and May when he transferred and sold his right to this technology. That's $400,000. No matter what you sell it for to anybody, that still is a lot of money. And that is a very big incentive to try to solve the problem. And there really was just no evidence that, as the court pointed out, that the problem could be solved. So we would respectfully request the court reverse the trial court and remand for further instructions, finding and awarding the plaintiff the damages that it proved at trial. Thank you, Judge.
Thank you. The court will be in recess for 15 minutes.